These are case numbers 20 CR 000020 and 20 CR 000021. Both cases, State of Ohio versus Troy C. Phillips. Mr. Phillips is in court, represented by counsel. Attorney Justin Weatherly, representing the State of Ohio, is Assistant Prosecuting Attorney Amy Alessi. Cases before the court for final pretrial. Both cases are going to trial on next Tuesday, September 22nd, 2020. These were set for trial for next Tuesday, back on August 5th of 2020. I met in chambers with both counsel, and Mr. Weatherly filed a motion for continuance of the jury trial. He says he has motions to file, including a motion to suppress and a motion to search the sheriff's office for video, if it exists, of an injury that Mr. Phillips says he sustained while in the custody of the sheriff, which he says was purposely inflicted by a corrections officer, and that may form a defense to the assault charge that he faces. In the 20 case, there are 2 counts: assault on a corrections officer, felony 5, which the state says occurred on December 13th of 2019. And that's the 20 case. And in the 21 case, it's a 3-count indictment that says on December 7th, 2019, Mr. Phillips assaulted a peace officer while on duty, felony 4, resisted arrest, misdemeanor 2, and committed disorderly conduct, misdemeanor 4 on that date. So Mr. Weatherly, motions to suppress have to be filed within 35 days of arraignment, and the defendant was arraigned on March 3rd on the 20 case. Let's see if it's the same on the 21 case. Right, March 3rd of 2020 on both cases. Why am I getting a request to file a motion to suppress 1 week before trial? I mean, we all this time that we had when we weren't having trials, actually we shut down right after, 10 days after March 3rd. So we've been, not shut down, we never shut down. We stopped having jury trials between March 13th and somewhere around the end of June. We had plenty of time in there to do the bench hearing on the motion to suppress.
There was a motion to suppress, Your Honor.
Do not speak.
Okay.
You cannot speak during this hearing. Let me speak.
Let's get one thing straight here. I have a calendar to attend to. I've got a job to attend to.
Mm-hmm.
There's a procedure for how this is held.
Yeah.
I can't be interrupted when I'm talking. And when I'm asking a question of your lawyer, it's because I am looking to fill a void in information that I don't have.
Mm-hmm.
You can't speak unless I tell you to speak to me. You can always talk to your lawyer
Yes, Your Honor.
in consultation. But I'll never figure out what's going on.
Me neither. Yes, Your Honor.
So Weatherly, what? You
Your
want to
Honor.
present a motion to suppress 1 week before trial.
And Your Honor, I do apologize for the delay there. I would like to point out for the record that I was not attorney of record for Mr. Phillips in March when this case initially began. I was hired a few months later, and between the time it takes to file discovery and get discovery, and I give the state credit, they respond very, very quickly in providing evidentiary discovery in this case, and in every case they do. But when I took over the case, Judge, the only hearing date that was set was, I believe, a September 28th hearing date on all the motions that Mr. Phillips had filed, I believe pro se, prior to me getting on the case. And so I knew I had some personal issues that were coming up later during my representation of Mr. Phillips, but I figured since there was no trial date set, I would have ample time to review the evidence, notify both the state and this honorable court of any motions should they exist, and get those filed as soon as humanly possible. It took me some time longer to identify a strategy for defense in Mr. Phillips' case once being retained. For one, Judge, as you well know, there was a lot to clean up. There were quite a few motions that Mr. Phillips had filed. Mr. Phillips can be difficult in discussing strategies and a plan of action in his cases. He's very vociferous in what he wants to do and how he wants to do it. And so those cause delays because I can't do anything without his authority, and I refuse to do things, Judge, that I believe are frivolous and I don't believe are appropriate in a courtroom setting. So there's a lot of discussions of what not to do and what I will not do, and as far as filing certain motions and subpoenas, and less time discussing what should be done. And in this case, I believe a motion to suppress would be one of those. Now, Judge, just so the court is aware, I understand that personal issues generally do not make their way into a courtroom, and they should not. But if you're asking for an explanation as to why I might be moving a little bit behind schedule, the fact of the matter is that my wife was due for a C-section on August 12th of this year. She went into labor prematurely on August 11th of this year and almost did not survive the childbirth. As a result, a lot of time that I would have been spent working on my cases and working on my clients, Mr. Phillips included, was spent with family affairs. I was out of the office for a prolonged period of time. My wife is still not completely healthy. Unfortunately, I've been delayed in getting things done for my client. One thing I wanted to get done for Mr. Phillips and should have gotten done by now is to draft a motion to suppress evidence as to the first case chronologically in as far as when it occurred, but the second case in as far as it's numbered in this case, which would be the assaults on the police officer, the felony 4 case. Judge, even in just reading the charges, you can see the potential for a motion to suppress, and that the alleged assault on a police officer occurred during a charge of resisting arrest following an attempt to arrest on a misdemeanor for disorderly conduct intoxicated. I think it is reasonable to question the probable cause of Mr. Phillips' arrest on that low-level misdemeanor charge, especially given the fine line between a misdemeanor 4 and a minor misdemeanor, which is a non-arrestable offense. So I would like to certainly delve into that issue. I believe it is highly relevant, and should this court find a motion to suppress well taken on that specific issue, it would be outcome determinative and potentially avoid trial. In as far as the first case, numerically speaking, but the second case, chronologically speaking, the assault on the corrections officer, there is the issue of my client's broken hand. I mistakenly called it a broken wrist earlier. My client, I did hire a private investigator and has pictures of his swollen hand that were taken in the jail 13 days after the date of incident.
That's from the public defender.
The broken hand would have occurred the same day as the charges of assaulting the corrections officer. Additionally, I just learned, according to my client, that the Lake County Jail is in possession of complete medical records regarding the treatment of his broken hand as he was transported to Tri-Point from the Lake County Jail approximately 49 days after the date of incident, after repeated requests from my client for medical treatment for that hand. Thirdly, Judge, there has been a subpoena requested directly from my client, not from me, but I will follow up with one of my own, for any audio or video recordings which would have depicted the breaking of my client's hand, or at least provide light, shed some light onto how that hand would have been broken. To date, the only recordings from the Lake County Jail that have been provided to the Counsel for Defense were of Mr. Phillips sort of breaking free from the corrections officer and running into a unrecorded office. I do not believe that that incident records any either assault on a corrections officer or perhaps any inappropriate behavior on the part of the corrections officer that may have taken place towards Mr. Phillips. We are requesting video of how it is that Mr. Phillips' hand became broken. We do believe that that incident would have taken place in front of a camera. We do believe that Lake County Jail either is or was at one time in possession of that recorded footage. We'd like to give the Lake County Jail an opportunity to produce that footage, and if they cannot, we would request an explanation as to why that footage is unavailable.
He's bringing me an ice pack
So,
on the camera, on the video that you have, showing me go out the cell. Officer Zupanzik and Corley will testify to what happened.
Let me get through this.
Okay.
So, Your Honor, I would both personally and professionally apologize for the delay in bringing these issues to the court's attention. I would respectfully request that this honorable court understand, given all the circumstances, both outside and inside the courtroom, as to the reasons for the delay. And I would be willing to sign a time waiver and have my client sign a time waiver in order to make sure that all of these issues are addressed, and so that none of the time that we are requesting is burdened upon the state or this honorable court. But in the interest of justice, Your Honor, I would like to pursue these issues so that my client cannot later claim either ineffective assistance of counsel or a lack of due process or the deprivation of the right to an appropriate and fair trial. Thank you, Your Honor.
So how would you propose, what exactly would be the steps? Let's assume I put on an order telling the sheriff and jail administration to produce the any video or audio recording of the broken hand, and or explain why they can't produce that.
I got the tape.
Troy, you cannot speak during this
Okay, I
hearing.
apologize. She just told me she's going to give it to me in the prosecutor's
Listen, you
office.
cannot
or
speak
not
during
to.
this hearing.
Okay, I
Please.
apologize. I'm sorry, Your Honor.
What did I say?
Your Honor, I heard you. I'm doing my best.
You're talking about the proposed steps to take if you issue an order to the...
So I issue an order telling them to produce video or audio recordings or explain why they can't produce them. And then what's the next step?
So, Judge, and I'm not trying to be argumentative, but I believe the next step would depend upon what that explanation is. So, for instance, if the explanation is, we know for a fact that that broken hand occurred in this corridor, and we have no cameras in this corridor, and we can produce records showing that we've never had any cameras in this corridor, and we can show you where all the cameras are, and you can see there's not one in this corridor, therefore it was never recorded, and that's the explanation, well, then that's the end of it, Judge. But if the explanation is, yeah, that would have happened in an area that would have been recorded, and it was recorded, but we recorded over it, or we didn't preserve it, or something happened, there was a glitch in the system, and for some reason we don't have it, then at that point, Judge, I would be moving for a request for an expert witness to review the hard drives which contain that, potentially would have contained that audio and video recording, to determine whether or not that audio and video is retrievable, A, and B, whether or not the fact that it does not exist, whether or not there was any foul play with regards to that. Meaning, was the data corrupted, or was it actually recorded over using the normal system algorithm?
So what's the date
December
that we are
13th.
talking about?
December 13, 2019, approximately 3 p.m. And it goes to
December
a
what?
serve. It goes to
Troy,
a
you have
serve.
to let me in.
Okay.
December what?
December
December
13th.
13th, approximately 3 o'clock in the afternoon, Your Honor. I usually like to get a 6 to 8 hour window, just to make sure that if the times are off, we don't miss it.
Their camera's cleared on the
Troy,
video.
this
they
was-
took.
Only speak to me. Do
Okay, I
not speak in this
apologize.
hearing.
This was 1,500 hours?
Approximately, Your
All
Honor.
right, so if I went an hour and a half before and a couple hours after, it would cover it?
Oh, yeah, you got it. 10 minutes prior to.
Troy, you only speak to me.
Okay.
You don't speak
and,
to the
and the
judge.
camera angle coming down that hallway that's on the elevators, because it shows this alleged chair throwing never occurred. All right.
So Judge, yes,
What floor?
First floor, booking area, cameras.
This was the booking area.
Yep, cell MH1. Camera is directly on the cell.
Cell which?
MH1. Captain Brooks was going to provide the video to me, but then she
Troy,
told me that the
you got
prosecutor
to speak
said,
to me. I can relay it to the judge.
"Can you give this to him
All right.
so he sees this?"
So-
possibly? This is all news right here. That comes from Captain Brooks, from the jail administrator. She came to my door personally and told me.
She's not going to come here and write my order for me.
Oh, I apologize, Your Honor. No, I was asking to get this to you so you can see what this came from
So-
Captain Brooks.
December 13th, 2019, from 1400 to 1630 hours, the booking area, cell MH1,
I said,
right? That's the date, the time, and the location, correct?
This is received by the Sheriff's Department, it's a subpoena from Captain Brooks from that date. That's what I need right there. They got it. She said the prosecutor's office would be giving it to me in the discovery phase. I tried to explain that to her. She said the prosecutor said to withhold the tape.
That has nothing to do with the judge.
Okay. No, I understand it has nothing to do with the judge. Your
So
Honor, I
yet-
apologize. I know that I'm not, my argument is with the prosecution.
Just stop.
Not the
Troy,
state.
just stop.
So, I still need,
Give me that subpoena.
if I write my order up and says in the order
What this
that I want
is.
all camera recordings on December 13th, 2019, between 1400 and 1630 hours.
What's 1400?
It's 2 o'clock.
3 p.m.
Stop, Troy, stop.
Do you want me to write it up 3 p.m.?
No, I do not, Your Honor. 1,400 hours, please.
It's on a subpoena.
Troy, you need to stop.
Okay.
$1,400 to 1630 hours in the booking area focused on cell MH1.
As well as the camera. Okay. As well as the camera from the
So Judge, any and all
first floor cameras.
any and all first floor cameras that would record in or around that area, I think would be
From the elevator down is pointing at their door.
That language covers it.
It doesn't point exactly into the sergeant's office, but the camera points enough into the down the pathway. I've already done all the investigation work myself. It's pretty simple. She just wouldn't give me the tape because it shows what happened. They didn't put me in segregation because Lieutenant Simpson seen what happened to me, and he
please
felt
stop
bad
talking.
for me.
Please stop.
So then, when did you first complain about your hand being
As soon
broken?
as it happened, the incident while my cell door was
Who
open.
did you complain to?
Officer Corley and Officer Panzik seen it. The officer, Sergeant Longbonds, who slammed my hand in the door, went and got the nurse and brought me an ice pack. That's how my door got open. Because he was bringing me an
All right,
ice
so you
pack.
complained immediately.
Absolutely. He slammed my hand
They
in the cell
iced
door
it?
3 times. Yeah.
Only answer questions. No extra stuff.
Okay.
And how was it broken? What was the mechanics?
Fractured.
The mechanics of it.
It was a fracture. I guess it was a hairline fracture. After 49 days, he was intercepting my
No,
text.
it didn't break itself.
Oh.
What are the mechanics of it? They slam your hand in the door?
There's a cell door shoot, right, that they give for the child. And after they kept me in the cell for 7 days and wouldn't allow me to use the phone. After that fact, after on Friday, I says, hey, I have court in Ashtabula. I need to call my attorney, please. He says, no. I put my hands outside the cell door, out the chute. It's a tray slot for when they serve child food. He says, put your hands back in the cell. I says, I'm not putting them back in. I need to use a call to call my attorney. He said, if you don't put your hands back in the chute, I'm going to slam it in here. I says, no, you ain't going to do that. Well, he did. Not one time. He didn't allow me to bring my hands back in. He slammed it 3 times. Officer Corley was right there at the fingerprint machine, as well as Officer Stupanzik and Officer McKenna. And they witnessed the entire incident happen.
All right, so
Sergeant
who were the
Longbonds
witnesses?
Stop. He speaks-
Officer,
Oh, who's the one that did it?
Lieutenant Longbonds.
Longbonds?
Officer Corley was right outside the fingerprint machine. Same as Zupanzik was sitting at the desk. And I believe an inmate by the name of Kenyatta Reed was on there. He's
All
on the
right,
video.
so Corley, who else?
Officer Corley and Zupanzik.
Zupanzik?
Yes. Officer Corley. Ain't no one.
And anybody else see it?
Officer Corley was right
What's
there.
the inmate's name?
Kenyatta Reed. He was getting fingerprint at the time. It's on the video. You have the actual tape of me running out of the cell, but they won't back the tape up 10 minutes showing.
Kenyatta Reed?
Yes. He's on the video too. He's on the actual tape, and there's another inmate.
You saw the tape?
Yes.
Okay. Oh, so you
I
have
have the
seen
tape.
the video?
Yeah, but they won't back
of
it
your
up.
hand being broken.
Remember when I? No. They won't back the tape
Please,
up.
Why don't you let me do it?
Yeah.
Okay.
So, Your Honor, the video that's provided is approximately 10 minutes subsequent to when my client is claiming his hand would have been broken.
Who brought that? Who brought that
That's the
forward?
video that the state has provided already.
But you told it. You told the
So-
state.
And that was
Okay, my bad.
tell you what, let's take a break. I'm losing my train of thought.
I apologize, man.
All right. Wait. When I come back, if you interrupt me again, I'm going to put you in the cell. You
I
can
understand
listen from
that.
the cell.
Stop.
Man, my motherfucking due process being violated.
No, he's trying to
Get
help.
the-
He's trying to help.
How's
but
it
you're
helping
not.
when they
You're
wait
not
off the
letting
tape?
him. Troy,
I've asked for the tape for months.
he's trying to get it for you, and you're
Well, she
stopping
got
him.
it.
No,
Give it to me.
Troy, you're literally
All right,
shooting
man.
yourself in the foot right now.
Okay, my bad. I was
Well,
just
you can
kidnapped
say my
out-
bad all you
I was
want,
I was
but
just
when
kidnapped
you're
out
in-
of my house and
when
put
you're
in
in-
jail and they got assaulted
Okay.
and they charged me.
Okay, well, when you're in solitary because you couldn't stop interrupting the judge, and you got nobody to blame but yourself.
I've been sitting in jail. I did 12 years in a motherfucking box, dude. You think I'm gonna sit here and be quiet?
He's
though?
trying to help. You're not
Hell,
letting.
she was giving me the tape, and the prosecutor's office told him not to. That's what what it says.
But
she was bringing me the tape.
The judge is requesting it, and you're stopping him from doing it.
You got subpoena power, right? Get the fucking tape.
What's
the judge need to get it?
Who backs up the power of the subpoena, Troy? It's not me. I don't have the
I don't
authority
know,
to do
but
it.
I'm fighting the judge and the prosecutor,
Okay,
not my
no.
attorney.
The
I apologize
judge
for
is
what's
the
going
one
on
who
with your
has
wife
the
and stuff,
authority.
man.
That's it.
Yeah.
So the judge is trying to
It's
do it for
exculpatory
you.
evidence in my favor. It's Brady versus Maryland. I'm asking for it, and I
Troy,
give it to you.
If you don't sit down and be quiet, then you're not going to get it. The whole purpose of this hearing is to get it, and he's trying to do it for you.
Get it.
Okay, well, you want to let him, or you want to keep interrupting?
Get it in the Court of Appeals, man. I'm suing the fuck out this place. Like I'm fucking retarded, man. Like I'm fucking retarded. I'm an American. I'm protected under the United States Constitution.
Yeah, except for the rules of court still apply to you, do they not?
Hey, man, the due process applies, doesn't it?
The rules of court do as well.
Okay.
The judge is trying to do something in this
I
hearing.
had-
And he's trying to do something to
All right,
benefit
okay.
you, by the
I
way,
got
and
you.
you're not letting him.
I don't know why they can't just give me the tape.
The judge is demanding the tape.
No, the judge.
And you're not letting
I'm
him.
going to say it got fucking destroyed is what's going to happen.
they're going to give the judge the same answer that they gave you, at which point,
The prosecutor's office advised me not to release the video that you requested for 12/30/2019. The prosecutor's office advised me to pass on to you that they will have the video and present it to you to the discovery phase. Signed, Captain
Right,
Brooks.
right. This doesn't mean that they have the tape. It just means that they have to give the tape to you following normal criminal rule procedures.
So you got the tape 10 minutes
No.
after on my cell
No.
recorded?
Where's that other piece of paper?
But you don't have it first. They tried to tell me they
Troy,
didn't
you're
have the
you're
tape.
misreading the answer that they gave you.
My private investigators got the shit from Lori Gladding, too, stating that the tape exists, but they're not releasing it because it's an ongoing investigation. So I got that email from Lori Gladding, too, to my private investigator.
I don't know who that is.
She's a jail fucking secretary next to the sheriff. Y'all know what happened, man. Just cut this shit.
This doesn't mean what you think it means.
I know what it means.
No, you don't. That's the problem.
I got the tape. So you mean to tell me you want
No,
back
this
the tape?
this doesn't mean that they have the tape.
I got the tape showing them bringing me an ice pack. Officer
Okay.
Corley's going to testify what happened to do slammed my hand in the fucking chute and broke my shit.
So
You know what I'm saying?
you're on the video getting an ice pack taken to you?
Yeah.
Okay. Well,
You got it.
all right. Troy,
comes to my cell. He
Troy,
told me to run out
Troy,
of the cell.
the
All right.
best thing you can do is to
Got it.
not open your mouth unless the judge asks you a direct question.
get
from
that,
here
but I
on.
like to
But-
have
But you don't get it.
I like to have things on the record so when I get there you can't say, well, you didn't argue that issue at
Okay,
trial.
but listen,
again.
if you want to say something, you whisper it in my ear, and then I put it on the record. You don't interrupt the judge.
I want everything on the record.
Okay,
I
well-
had a suppression, everything filed, and you withdrew all my motions for what reasons I don't know.
Because the motions that you filed
What?
didn't argue the right things or the right
I
way.
filed a motion to suppress the illegal detention of me. What's wrong
Okay,
with
that's not, is that what I just said I was going to argue?
that? Not bad, man.
No, it's not.
I just-
Completely different issue.
It's cool. I got kidnapped from my house. I got a cop on the stand lying.
Troy,
saying
I
kidnapped
need you to make sure that you don't open your mouth again when the judge comes back out. Because if you do,
That's cool. I already see
It's
where
over.
this is going, man. It already is over.
he's doing his best to make sure that you are not deprived of any of your constitutional rights.
I know
And you're
I-
fighting him.
I know what's going on. I'm fighting.
No, you're not.
I'm fighting.
You- no, you don't.
I'm prosecuting my own attorney now.
No, your attorney, along with the judge, are out here making sure that your rights aren't deprived.
How about you seen the tape? They've seen the tape, and you just say, "Let's just dismiss this nonsense and get on to the
Okay,
fucking."
'cause that's
next
how it
one."
works. You're right. That's exactly
That's
how
what
it
a
works.
boss does. You a boss, right? I
That's
know you
not
are.
how it works.
Man, come on, man. I've checked you out. I've looked you up.
Right.
You a dog.
And
So-
I get cases dismissed probably a little bit more than the average bear.
You a
But
dog.
you do it the
man.
right way.
But you. I can't get a phone conversation now.
You can when I need to spend my time doing the two things that I
get
want to
that, But you
do.
tell my people. Way ahead
Troy,
of me, Troy.
we'll talk about
That's
that
what I'm saying.
later.
I can't get a phone conversation. Now I get to see you. Now it's some bullshit.
But you and I talk in circles. We don't get anything accomplished.
Hey, real simple. You got evidence? Show them what the fuck happened. Dismiss.
I'm going to tell you the same thing
got
that I told you
kidnapped.
before. I'm going to file a motion to suppress on the one case, and
Cool.
we're going to figure out what's going on with the tape
That's
in the
all
other
we
case.
need to do, man.
Okay.
Officer Corley and Officer Sapanzik, if they don't have the tape, are going to say what the fuck happened.
Well, maybe not. I wouldn't.
guarantee you will, because they ain't going to lie.
Well,
Watch.
okay. All right. People never lie in court.
Well, I didn't, I've learned a long time ago what it was, but most people that are an American, when they get under that shit and they hold some weight and they wear a badge and they're an officer of the law, most of them, pretty much 90% of them, is going to tell the truth. They're not going to lie for another motherfucker, man. Just because they got to hold an oath and they wear a badge. Not saying all cops are bad cops. There's a few.
I'm not singling out police
Okay?
or non-officers.
Well, that's what
I'm
you
saying
just said.
people in
They're not
general.
going to lie for the guy. I've already went through this. I know what they're going to say. He said, Troy, why would you call me up there? I said, you're going to tell the truth, right? He says, absolutely. I said, that's all I need you to do. He said, bullshit. They put me in the fucking...
Did they provide the statements to your private investigator?
Huh? I can't get no one's talked to him. The prosecution's asking the guy, Mark McKinnon, saying he hurt his back in the takedown. Well, I got video camera footage of him after the takedown, marching around, going to the hose and getting it to hose me down. His back looks pretty good 20 minutes after that, when you can read his lips talking.
So,
officers.
Troy,
Yeah.
what this says is that they had cameras installed, but those cameras were not recording at the time.
You got the tape. You have a tape of me running out the cell with him bringing me an ice
Clearly
pack.
they were recording.
Yeah, absolutely.
And
And then she said she came to my cell with Officer.
So Troy, stop.
Yeah, then she
so
came
that's what you need to let me litigate at the right time.
Just
That's
get the
not
fucking-
today.
Just get the tape, man.
That's not today.
That's all we got to do, man. That's all I need. Just get the tape. It's going to show exactly what happened. It's going to show this
Okay,
miraculous
so
chair
Troy,
throwing.
Troy,
Because nobody knows
Troy,
about it. It doesn't
just
exist.
promise me you're just going to let me speak and you're not going to say anything the rest of the hearing. Because I'll bring up those issues.
That's
to the
cool.
judge.
Just make sure I get all these transcripts from the beginning.
Just promise me you're not going to talk when he comes back out.
Am I gonna? If I don't say something though, am I gonna get
If you-
fucked because I didn't raise that issue and put it on the record? Because I want it on the record, man. Because that's how I feel is going on.
Troy, I'm going to put those 2 pieces of paper on the
Because
record.
it's like when I speak and I say something, what happened? Everyone gets mad. Like, damn, he's putting it on the record. He said that. Why'd he do
Troy.
that? I know, right? Because it's me fighting for my fucking life, man.
Troy, you're shooting yourself in the foot.
I'm not.
Yes, you are.
You got the evidence. You got the tape.
I don't.
Give it to me. They got it.
I don't have it.
The prosecutors got it.
She
I
doesn't
made a
have it.
report with their public defender's office, and they came and took pictures of my hand. Troy Phillips called the jail Thrax on Thursday, 12/26, looking for the sheriff. He claims that Sergeant Longbonds assaulted him by smashing his hands in a shoe. He also says that he has filled out many inmate request forms directed to the sheriffs regarding this, but nothing is being done. I told him I would let him know and to fill out another form directed straight to the sheriff. Your response,
so we'll
did he call collect?
So we'll get
Captain Brooks,
we'll get
I need to
those
speak
requests.
with you. On December 13th, I was assaulted by Sergeant Longbonds. He slammed both my heels in a door chute. The nurse was called to see my injuries and gave me an ice pack. I have been yet to get an x-ray. I would express my constitutional rights to press assault charge against Sergeant
see.
Longbonds.
Stop reading it. I can read myself.
You can talk to your attorney about this. We will do nothing about this issue regarding this issue. Well, okay then. I talked to whoever the attorney was. They came over and took pictures.
I will put these on the record. You don't say a word. Got it?
So, Mr. Weatherly, do you have a proposed order that you want me to sign?
I do, Your Honor.
Let me see it.
In writing?
Yeah, you don't have one.
No, I'm sorry. I do not. I do not have one in writing,
All
Your
right,
Honor. I
but you
believe-
have one roughed out?
Yeah, I do, Judge.
Let me hear it. Let me hear what it sounds like.
So we would respectfully request from the Lake County Jail, Lake County Adult Detention Facility, which is, I believe, its formal name, to provide any and all audio and or video surveillance from December 13th, 2019, from 1400 hours to 1630 hours, using any and all cameras in or around cell number MH1.
Okay, and,
That would be on the first floor, Judge.
pardon?
That would be on the first floor of the detention facility.
Okay, the booking area is only on one floor, is my understanding. So then, Ms. Alessi, do you have a problem with that order?
The only problem I would have with that order is what we had discussed in chambers as far as potential security issues. So I would ask if we obtain this video, I don't know if it's best to review in camera, and not necessarily that we just provide straight to defense through our typical discovery process.
Okay, so we can,
Any and all cameras surrounding that area.
respond to what the prosecutor just said.
My apologies, Your Honor. I can't listen to two people at the same exact time. If it could be repeated, I would appreciate it.
The only issue I would have with the order is the potential security issues that the judge had raised in chambers, just as far as what is able to be seen on the video. I would potentially ask for an in-camera review of that footage so that it's not provided through our typical discovery means.
And the sheriff can provide input. If he says, no, there's no security issue with that, then that's fine. If he wants to assert the security issue, then I would have to have a hearing on that to determine whether that information would constitute a breach of security.
So, and for the record, we would have no objection to an in-camera inspection as opposed to standard discovery procedures. We would just like to state that the order should include any and all cameras that would have an angle to that area as opposed to any one specific
Anything
camera.
that could possibly pick up anything there.
Correct, Your Honor. Correct, Your Honor. Thank you, Your Honor.
So, once we have this, what are you going to do with it?
Well,
Their answer.
so Judge,
Either they produce the video or statewide it can't be produced.
So Judge, to that end, I, on behalf of my client, I want to point out what answers have already been given with regards to this. So initially, my client received a response saying, please be advised that the cameras in the booking area were not recording video in 2019, and they've since been upgraded with new cameras that do record. Installation of the new cameras on the first floor, including the booking area, were not installed until around May of 2020. So this is a letter from Captain Cynthia Brooks, jail administrator, to Troy Phillips after he specifically requested the video himself.
What date was that?
She dated this August 5th, 2020. Okay?
And I showed.
Now, Troy, do not speak. So Judge, the reason I find this particular letter questionable is because the actual video that we do have is from these very cameras, which she says weren't recorded. They clearly were. We're just asking for the footage that would have occurred
So
10
they're from the same security cameras? On what date?
So the video we have is from December 13th, 2019, Judge.
Okay.
It's just 10 minutes after what we want.
I guess the clarifying question I would have here is the video that we provided the same cell that he was in when his hand was smashed in the door.
So that's the question. That's the question. So thank you for bringing that up on the record.
Because I would clarify as to whether or not there is a true statement or false statement if those cameras were in fact recording, if that's the cell he was in. Then we know they were
Okay.
recording.
But the question is, if someone were trying to hide the video of his hand, one hand or two hands being broken?
One hand, Your Honor.
One hand.
Which hand?
My right hand. I'm not going to sue anybody. I don't want no
Please
problems.
stop talking. Please stop talking.
Okay.
When spoken to.
I'm not trying to sue nobody. I just want the cases.
So
I'll sign the shit now.
if someone were to try to hide the video of the hand being broken, it'd be the same motivation to try to hide video of an assault that didn't occur, right?
I could see yes, we can make that argument.
Okay, so it wouldn't, you couldn't make the argument, well, they're hiding the one video because it shows Mr. Phillip being victimized, but we don't, they don't have video of the officer being victimized either.
To date.
The camera angle
Troy,
will be
Troy,
if there
stop.
was an officer victimized, though, which I want to
Troy,
say is there
Troy,
would be. Okay,
you
my
have to-
bad.
you have to
I got
stop.
you. I got you.
So, to clarify what Mr. Phillips is trying to say is there's a different camera that would be angled down the hallway where both incidents would have occurred. I believe the jail is trying to say that, yeah, they had one camera working in the booking area, and that's why we can see Troy running into the sergeant's room, but that other camera, even though it was functional and angled right at where the incidents would have occurred, wasn't recording at the time and didn't start recording until we upgraded the system in May. So that is a potential answer we might get from the Lake
So
County Jail.
what is the time that the state says that the officer was assaulted?
You see me,
Troy, you will not ask the question.
353.
Stop.
Yeah, if I can recall correctly, it was just around 4 p.m. because I believe we provided like a 10-minute range of footage to defense is what I received as part of the.
All right. So going to 1630 would cover, from 1400, cover all of that.
I believe so, yes. I don't want to commit to that time because I don't have it written down in front of me. I know I've watched the video several times, and it's around 4 p.m. Whether we start 10 minutes prior to 4 p.m., 1,600 hours, and go to 1,630 hours.
And does the state say that the assault allegedly occurred right there in front of MH1?
No. The defendant ran from the cell MH1 across the screen into what, I haven't been there myself, but what I was told is the sergeant's office, and that is where the assault occurred. And we have pictures of the sergeant's office. I know it exists, but I was told at the onset of this, when I first received the case, that there was no cameras inside to capture what occurred in the sergeant's office.
So they say that Lieutenant Longbonds was assaulted in the sergeant's office?
Yes.
No.
Troy, stop. It's their case, not
Okay.
yours.
Look,
All right.
how am I going to figure out what's happening when I want to nail her down.
I got
I don't
you.
want to nail you down. Put him in a cell. I can't get this thing done.
I know. I like to explain what happened because the man says that I threw a chair at
This
him.
is not your time to explain. I want to nail her down.
My bad. I don't know. I like to be out on bond. I got kidnapped, assaulted. I got assaulted. I'm still sitting in jail.
This will be a fun trial.
You got the audio on, and I'm just waiting for them to situate it in there. All right, so Ms. Alessi, the state says that Lieutenant Longbonds was assaulted by Troy Phillips in the sergeant's office at a few minutes to 4 p.m.,
That is
1,600
correct.
hours on December 13th of 2019, right?
That is correct.
All right. So then we want you, and you have video of him running to the sergeant's office.
Yes.
That's a different camera than the one that would be focused on the front gate of MH1?
That I'm not entirely sure. I don't know if that cell he was in was MH1. I could probably easily find that out. But that's what I'm unclear of, is if the video footage is of that same section of cells, or it is the booking area. I know that. So if that's where this alleged incident occurred, then yes, we do have the camera footage I have is from a camera directed at those cells.
So in seeking evidence, what has the state done with regard to preservation of video evidence that may exist?
The state has not done anything with preserving any evidence outside of what was initially provided. I never requested specifically that the sheriff's office.
So whatever the sheriff's office provided, that's all you have?
That is all I have.
You didn't inquire further?
I did inquire further, just if there was video footage of the actual sergeant's office where the assault occurred. I was told that there was not camera footage there. After Troy Phillips had filed his own subpoena with the court directed to the sheriff's office for that specific time frame, because the subpoena was not properly filled out, our office had instructed the sheriff's office not to provide it directly to Troy, but to provide it to the state, and we would provide that video to defense. Again, that same time frame he was requesting, the same video was given to me that I had already provided to defense. Since then, I have not followed up further to see if and why I wasn't given that full time frame. But so up to date, we only have the footage that was initially provided.
All right. Then you didn't ask specifically for what Mr. Weatherly is asking the order to provide?
No, I have not asked
All
for
right.
that specifically.
That's an important question to ask.
It is, and this is, I would have asked it sooner had this been raised by Mr. Weatherly prior to today. But this is the first the state is hearing of any discovery issues.
Your Honor, if I may, I'm not faulting the state for any improprieties in discovery, much less Ms. Alessi whatsoever. I think if this hearing has proven anything, it's the difficulty in communication with Mr. Phillips. In order for a defense attorney to effectively represent his or her clients, there needs to be effective communication between the two. Communication has never been easy throughout this process. So I want to make sure the record is clear that the state of Ohio, and through its prosecuting attorney, is not at fault in any way, shape, or form in this case. It was a delay on my part in making the proper request due to a lack of communication with my client, and I'd like the record to reflect that.
Now, you said that Mr. Phillips hired a private investigator.
That's correct, Your Honor. In fact, I've been in touch with the private investigator, so I know that's
Did that
true.
investigator interview Kenyatta Reed?
To my knowledge, the answer to that question is no.
Why not?
Your Honor, I would love to ask him that question personally, again, because of my...
You know, I can see Corley and Zupancic maybe not wanting to talk with a private investigator, but Kenyatta Reed, who's a fellow inmate, I would think that you should be able to talk to him and find out from him what he saw.
So when I spoke with the private investigator, my understanding was the investigator had...
Who was?
Judge, you're going to have to give me a break on that one. He's the one responsible for taking the pictures of Mr. Phillips' hand while he was incarcerated. I'm not... And it does show that his hand is swollen. I've got... actually, you know what? Hang on. Maybe I've got it written down in the file. Well, I've got his phone number, Your Honor. I don't know if that's helpful, but I can't remember. I don't have his
First
name.
three numbers after the area code.
906-2577. It's a 216 area code, Judge.
Roger Martin?
Who?
Roger Martin? If it's the public defender's investigator, I don't know. But
Oh, okay.
It's a 216 area code. It's not a 440. I don't know if it is.
No, I think Roger might have a 216.
I'm not sure.
Do you know if statements were taken on behalf of the state and the investigation from Corley and Zupancic?
No, I do not have any statements or even witness statements from them in regards to the assault on Sergeant Longbonds.
Well, you have a written statement by Longbond.
Yes, but not from, I have from Longbonds and Officer McKenna, who, to my understanding, were the ones in the office at the time this occurred, not from Corley or Zupancic.
So McKenna was in the office, the sergeant's office.
Yes.
Is McKenna a sergeant?
I will have to double check on that. Because he was actually named as a victim when this case was bound over, and after speaking with McKenna and reviewing his injuries, we felt that it did not warrant felony charges. His injuries.
All right. Longbond's injuries are, you said, a strained back?
No. When Troy was talking, he was actually referring to Officer McKenna, who strained his back. Sergeant Longbond sustained a laceration to his thumb that required stitches.
And how did he say he got that?
When Troy ran into the sergeant's office, he began tossing furniture and ripping things off the walls, and as they were trying to apprehend him, he threw a chair at Officer Longbond, which caused the laceration.
All right. Mr. Weatherly, I'd like you to send me a proposed entry by email. It won't be the final entry because I'm going to put my own touch on it, but get that to me. The motion to suppress that you're talking about was the probable cause for the disorderly arrest,
That's correct, Judge. That would be the
and that's the
basis.
sole basis of it?
Without having the yes, actually. Yes, Judge.
Okay. That's a narrow issue. Is there one arresting officer or two?
There was initially 2 arresting officers. If he's just challenging the probable cause, there was 2 officers that responded to the home. It was after the initial arrest that basically all of Madison Police Department responded.
Okay. But there'd only be 2 witnesses to the probable cause for his initial arrest?
I believe so. Officer Amy Spencer, and I don't have the other officer's name in front of me, but she was the responding officer.
Now, if there was no probable cause for the disorderly arrest, that means that the resisting would have to be dropped, because you can only resist a lawful arrest. That's an element. And if there was no probable cause. However, I don't see how it gets rid of the assault.
And I did research this exact issue when I received the case, just to look at the strengths and weaknesses of any case assigned to me. And at the time, I don't think I could pull it up on the spot right now, but I did find case law that said even if it was an unlawful arrest, it doesn't justify an assault on a peace officer.
Right, that's what I just said.
Yes.
An unlawful arrest obliterates a resisting, but not an assault.
That's my understanding.
Nobody has the right to resist or to assault an officer who's arresting him, even if the arrest is without probable cause, because, and there's a great public policy reason for that, we can't have defendants litigating this in their mind and deciding, well, I'm going to assault this police officer here because I don't think the arrest is with probable cause, and the officer saying, well, I have probable cause. No, you have to submit. If a police officer says you're under arrest for whatever reason, you have to submit and argue it out in court. And that's one of the biggest problems we're having these days with this movement. People don't want to submit to arrest and have their day in court. They would just rather shoot the cops on sight. Are you available to try that this week sometime? That's a narrow issue.
Yes,
It would only take probably an hour to 2 hours max,
I just look at my calendar.
and we can get to the bottom of that issue right away.
Yes, I have availability this week.
Knowing that the trial is probably going to be continued because of the video issue, it won't be continued long. But so, if I have the time, and I do, I would rather take care of that. And I'm thinking early Thursday afternoon.
That works for me.
Judge, I absolutely can do it this Thursday afternoon. I would be required to disclose to the state I have an audio recording, albeit not a transcript of the preliminary hearing in that case. So I would need to get that over to the state immediately.
Okay.
I wish it was a transcript. I prefer them, but I don't have one yet.
It's just the audio of the
Just
preliminary hearing?
Yeah, it's
I
not.
have that.
Oh, you do?
Yeah, I think we provided it.
Okay, all right.
Discovery.
Yeah. It's not a transcript, it's just audio. I wanted to make sure you guys
Okay.
had it.
And the arresting officer testified at that. That wasn't a waived prelim.
It wasn't the arresting officer that testified at the preliminary hearing, if I recall correctly. It was Sergeant Jason Clark who testified.
I thought it was Clark as well. In Judge.
Does he know anything about the probable cause?
Up to this point, no. I mean, I haven't.
No. Does he? What did he testify to if he wasn't in on the arrest?
To his other officers' reports.
Okay. Yeah. Well, that doesn't help me out
Yeah.
much.
And that preliminary hearing, Your Honor, was conducted pro se.
But that was just for the initial arrest. I mean, Sergeant Clark testified to the injuries he sustained, but he wasn't present at the home when they arrested Troy.
Okay. So, Thursday afternoon, 1 o'clock?
I'll be here, Your Honor.
I'll just have to make sure my officer is available, but I'm sure they will do their best to make themselves available.
And, Judge, do
So that's,
you want me to get a formal
17.
motion in between now and Thursday?
Yeah. So file your motion tomorrow. It doesn't have to be heavily laden with law because it's sort of standard. If they didn't have probable cause to arrest, they didn't have probable cause to arrest. You can certainly follow it up with any legal issues that may arise that I want you to brief after that. But just get in the parameters of the motion to suppress so that the state knows there's a beginning and an ending, and it's in this box that she has to prepare for. Since there was no warrant, the burden is on the state. What other issues?
Judge, those are the only two. Just the video and the probable cause issue on the other case. I'll get a proposed JE into you, and I assume I can just email that to your court. And then as far as the motion to suppress goes, I'll have that e-filed by end of business tomorrow, and I'll courtesy copy an email to the state as well.
Thank you. And as part of the court's order for the video or any video or audio footage, are we also going to be requesting Mr. Phillip's medical records? I mean, I guess it's not as, if you see it happen, then the medical records don't necessarily matter, but if you don't see it happen.
So I do have a copy of a jail request form from Mr. Phillips that's dated December 26th, where he says that he's requesting medical treatment for his hand. So there is records in the jail of his request for medical treatment, and according to Mr. Phillips, they are in possession of his complete medical records. So I can issue a subpoena for those, along with the judgment entry, proposed judgment entry to this honorable court.
Okay. So I want all their records regarding his injury too,
including
in
the
that
jail.
video order.
Okay. So I'll just put it in the judgment entry, the proposed judgment entry then.
All right. Anything else?
Just in regards to the trial, I'm only asking because I would typically spend this week prepping for that trial. I don't know if I should continue to do that.
No.
Okay.
We got to get these issues nailed down.
Okay.
Even though they're delinquent issues, we need answers to these.
Okay. Thank you.
All right. We're adjourned.
Thank you, Your Honor.